Hi, Ms. Burley. I forgot to mention, if you represent the appellant, you're entitled to reserve some of your 20 minutes for rebuttal. So if you'll let me know when you get ready to start, I'll try to give you a heads up when you get to the point that you would, for the minutes you would like to say. So, Mr. Morrow, you're up.
I'd like to, good morning, Your Honor. May it please the court. I'd like to reserve 5 minutes for rebuttal.
Sure.
May it please the court, Your Honor. This case, in this case, the lower court erred when he found that the jury could not have concluded that the words remain in violation following notice by the association meant that Ms. Norman was entitled to notice prior to the toll for several reasons. First, the under precedent, we cited in our brief, the issues related to the interpretation of documents are generally issues of fact. It is at the very minimum clear that there were different interpretations of these very words. And the
Well, you not only have the documents, right? You have the documents which talk about notice and the documents which also basically say failure to receive any notice of a violation should not be grounds for relief of any kind. So you have those two things, one requiring notice, one saying failure to get it isn't going to give you any opportunity for relief. And then you've got signs all around the property, basically letting you know it's a no-tow zone and you can't park, and the regulations are specific about parking in the grass. So you've got all that kind of in this mix, right? So it's more than just interpreting the document. It's the parking signs and all of those other things.
That's correct, Your Honor. And that's precisely why our cause of action is under 71507 Florida statutes, the only towing statute in the Florida statutes. And the association documents did not give Ms. Norman a cause of action. It only provided the rules of the game. And when the association moved for summary judgment, it is they who said that these are the documents that apply, and therefore that Norman was violating those documents. So by us relying on the very next page, we stated that notice was required, that defeated at the very minimum summary judgment, and the jury should have determined that whether or not under these documents and under Florida statutes, Ms. Norman was entitled to notice.
But isn't it a question of law, really? It's a question of law. What the statute requires strict notice, right? And that's and determining what that is probably a question of law, because the facts are undisputed, right? I mean, the facts are that she parked in this narrow space. A small portion of her rear right tire, unfortunately, was on the grass. I mean, it's a de minimis violation at best. And when you read it, you scratch your head and go, why are we here? This is like de minimis, but we're here. And it is, everybody agrees with that, though. So the facts are really in agreement. It's really a question of the law, the interpretation of this document, interpretation of the statute. That's really a question of law, isn't it? The facts are not in dispute. There's nothing for the jury really to figure out, right? Factually, I mean.
To the extent, Your Honor, that the towing statute permits only tows of vehicles that do not have permission to park where they were towed from, then the permission issue is what the judge decided that was factually undisputed.
Well, it's clear as a resident there, she has permission to park in the parking lot, and she had the appropriate decal or sticker or whatever it is that authorized her to do it. The problem, of course, is she had that tiny part of her tire on the grass, which no one has permission to do. The parking regulations are really clear about that. So she's got permission to park within the community, but she doesn't have permission to park on the grass. And I don't think that's really in dispute, is it?
No, Your Honor, but we argued that whether or not she was actually parked on grass within the meaning of the documents, and she testified in her deposition that I did not intend to park on grass, or I read that clause as to you made the grass a parking space. And since the parking was so narrow and she was trying to avoid the car next to her, so she was placed in a lose-lose situation where she hit some grass at a minimum or parks dangerously close to the vehicle next to her. which at the time there was one in the other side. So the factual setting here, where she was in this impossible situation where she may violate or she may hit someone, make this a factual pattern.
Is there some exception though in the policy for some exigency? Because if the undisputed facts are that she's on the grass, then as Judge Morris said, isn't it still just a legal question unless there's some exception in the policy for exigencies such as there's not enough room left in the available parking spot because the car in the next spot is too big?
We argue, Your Honor, that it's both. The legal question is whether or not 71507 requires notice of the type of the condition that will subject you to tow, because there's two requirements. One for an authorized vehicle, the signage type of notice, which it is undisputed in this case that there was signed, and that doesn't apply to Norman because she's a resident and she was parked in a designated parking space. And the second type of notice that 71507 speaks is of unless you've given them personal notice. So then we go to the question of what is personal notice? If personal notice means the general rules which you receive before moving into a community, we argue that that cannot possibly mean any definition of personal notice because she didn't know that she had been in the grass. And we argue that that factual setting could have been decided by the jury because the regular practice of towing companies is to post notices on windows and to give, that's how they behave. In this case, they didn't do so. So it's both legal to the extent, okay, was notice required? Ashburn argues we did not have to give you notice. The signage notice for an authorized vehicle suffices or complies with the statute. We argue no, there needs to be notice as to what is going to subject you to a specific tow.
Are the rule? What about the parking rules? Are those notice of the notice that she didn't have permission to park on the grass?
Correct. The parking rules would give her notice of what she cannot do. Now, two things. One, we allege that she was not parked on grass. She was parked on a parking space that they happened to manufacture in an extremely narrow way that made it impossible to not touch some sort of grass. And two, that the document itself says, if you remain in violation, we will tow you. So following
that second argument sounds like you're answering my question in the negative, that the rule does not require the notice required of the rules. In other words, let me put it a different way. Even if under the statute, the rule which provides her notice that she does not have permission to park on the grass, even if that statute's the notice requirement of the statute, it doesn't establish the notice requirement of the rules themselves, because the rules themselves require you to remain in violation after notice. But if that's true, my question is that a cause of action based on the statute? Because that requirement is in the rules themselves. The chronological, you're assuming your argument is correct in the chronology of the notice requirement, which is that the violation must persist after notice. Then how does that give you a cause of action under 71507? Because that chronological notice requirement doesn't appear in the statute.
Because, Your Honor, the statute provides for tow without permission. So Norman had permission. What's the source of
She didn't have permission to park on the grass.
Correct. So she didn't have permission to park on the grass. But the source
Under the statute, she had notice of that. Right? Because under the statute, there's no provision in the statute that says you have a cause of action if you don't comply, if you don't comply with the notice provision of your HOA rules. It just says you have to have notice. And doesn't she have notice by virtue of the rules that say you can't park on the grass?
not of that particular instance, because we link permission to two things.
But where in the statute does it require notice per incident?
Well, the statute.
Why can't it just crowd general notice about what you're permitted or not permitted to do?
Because the statute uses the words personal notice. it uses the word unauthorized vehicles for signage notice. And in this case, the signs didn't say don't park on grass. The sign, all they say is unauthorized vehicles will be towed. That's not subject of debate here, it's an agreement. So the other section of the statute says unless personal notice is given. Now, our cause of action is based on we had permission to park, and there's only two sources of permission, the decal and the rules. So the question of fact that we state it's was erroneously decided is whether or not hitting some blades of grass on a place that it was almost impossible not to do so was a violation of the rule, and therefore it revoked the permission she had to be parked where she parked. So that's essentially where we are. It is an issue of fact that the jury could have decided that under these circumstances, that is not really parking on grass when they designated that space like that. In fact, the circumstantial evidence presented after that reflects that this case itself has provided a fix to that because the two narrow spaces now are one single space. So it's
I can't speak for the other members of the panel, but there's a picture in the record of a tire on grass. So I'm personally, as a member of this panel, asking you to address an argument, presuming right now, for the sake of this media discussion, that there's no dispute of fact that she's on the grass. And what I hear you saying is that under this statute, because it uses the word personally, the notice cannot be the rules that say you don't have permission to park on the grass. You're saying that under the statute, the person must be personally confronted after she parks on grass before a tow truck is called.
Yes, Your Honor, and this is not unusual. This is the notice requirement. It's in every single aspect of our legal system, the contract, etc. And it's actually the behavior of most towing companies and associations throughout the state of Florida. So it's not what we argue is, we in our brief cited the example because we've seen this is our practice. We practice towing litigation situations in which a vehicle registration falls off the ground or is stolen, and therefore should the vehicle owner be entitled to notice of that condition, which he didn't know at the time he parked. It's very similar to the situation with Miss Norman. I mean, the car could have slipped down for all purposes, or situations in which the requirements are that you cannot park with a flat tire. What happens when the car deflates after parking? So our argument is that the personal notice requirements on Florida statutes and on the document itself would require, even if we assume as a fact, as Your Honor asked me, that it was parked on grass by one tire being partially parked on grass, even in that situation, that notice was a right that she had, that Ashburn cannot enforce the duty by taking away the right, because that will make the following notice by the association requirement meaningless. It might as well not be there. So under precedent that I'm sure you honors know, we have to find meaning on all the words placed on that document. I believe my time has expired.
Mr. Moore, I show you still have 2 minutes left in your initial presentation if you want to keep going, but you're welcome to stop now and save you time for rebuttal.
No, I will continue. So in addition to this, the association is arguing that they were not on notice of this cause of action, that somehow we had to attach the policy in our initial document, but we rebut to that, Your Honors, that we didn't need to do so. Under the rules of pleading in small claims court, we were not required to do so. And in addition to that, this was a case where they prevail on summary judgment, and they are the ones that were saying this document said X. All we did was rebut. It doesn't say that. At a minimum, it contradicts it, or in the alternative, there could be two interpretations as to what the meaning of that document is, and therefore that's a question of fact for the jury. I will end my presentation there, Your Honor. I'll reserve for rebuttal.
Okay, great. Ms. Burley, you're up.
Good morning, Your Honors. May it please the court. A phrase, Your Honors, I'm sure have heard many times that this is a simple case. In July 2020, when the appellant's statement of claim was filed, this was a simple case. In their statement of claim, they allege that Ashburn failed to strictly comply with the requirements of 71507 Florida statute when it improperly caused Norman's vehicle to be towed on the false premise that it was parked on the grass. That is a direct quote from the statement of claim in this matter. That was the playing field that the appellant set. That was the issue that was raised, that was the foundation for this matter. The factual issue of whether she was parked on the grass. That was a matter that your honors have already picked up on, that the trial court determined has been settled. As your honors have all seen, that there's the picture in the court file.
But you know,
from-
the thing that I keep having in my mind as I read this case in preparation for today, this of course was very heavy-handed by your client. This is a de minimis violation at best. I mean, the tire is barely on because she parked in a space that wasn't big enough. And yes, she had a choice to go park somewhere else. She could have done that. But I really wonder, you know, is this really even a violation of parking on the grass because it is so de minimis? And it was created by your client by putting too small of a parking place out there. So I've read some of the arguments that she has not even acquiesced that she parked on the grass. And probably it's because this is such a de minimis violation. What do you think about that? Is this really a parking on the grass, or is this just so de minimis that she substantially complied with the parking regulations?
Your
And
Honor, I'll-
say before you answer that, I would use the term incidental. Is an incidental tire on the grass, parking on the grass under the, as you know, the meaning of the rules.
Your Honor, what I would say is that this is not the situation that counsel has argued, where this is a few blades being touched by a tire, part of a tire on the grass. This is a tire squarely on the grass. This is a tire that came off fully off the pad and landed itself on the grass. And that is an issue that the trial court determined, that this was a tire that was fully parked on the grass.
A tire on the grass, not 4 tires on the grass, not 2 tires, a tire on the grass.
And not just a part of a tire on the grass, not even a full tire on the grass.
I would argue that the picture does show a full tire on the grass.
The picture I saw sure didn't look like a full tire.
Let me ask you this about the notice. So if the notice is, if the violation if the entitlement to be towed under the parking policy only arises if a violation, if a car remains in violation following notice, doesn't that presume that there must be notice of that violation? In other words, what's a fair reading of that provision that accords with, you know, logic and common sense? If I were to read that, that must mean that I get notice, and then I only get towed if I remain in violation after I've been noticed of this specific violation.
And Your Honor, speaking under the Ashburn's rules, correct?
Yeah, parking policy. If it
Okay.
remains in violation of the terms and conditions of this declaration following notice by the association.
So the rules do state following notice by the association. I would argue, now that issue was not pled as part of the appellant's case, but I would argue that the rules do not state the manner in which the notice needs to be provided, personal or otherwise.
But
that-
it doesn't state the manner, but it seems to indicate the chronology. And the chronology seems to mean that there must be a notice after a violation. Otherwise, it wouldn't make sense to read that sentence. It wouldn't make sense to say that the right to tow arises only after it remains in violation following notice. So a general notice that precedes the violation, to it, the parking policy itself, can't serve as the notice that following which the remaining gives rise to the entitlement to tow.
There's also towing signs throughout the community that.
Yeah, but the
advise on-
towing signs just refer to the impermissibility of unauthorized vehicles to be in the parking lot in the first place. They don't say you can't park on the grass.
That is correct. They do not specifically say they cannot park on the grass.
It's
So
sort of
So
along
how do you
those
read the, oh,
lines.
go ahead, Judge.
No, does the record reflect whether the association called the towing company to tow Miss Norman's car, or is the towing company coming on to the homeowners association property and patrolling for violations?
I believe, as I recall, the record reflects it's the latter.
That the towing company unilaterally, on its own initiative, found the violation and towed.
There's a contract and agreement between the towing company and the association.
So if, as Judge Atkinson is, I don't know if he's arguing or implying, you need to have a notice that you are in violation and then remain in violation before you get towed. That's not going to happen if the towing company is patrolling the property and towing whoever it finds in violation, as a practical matter, correct?
Potentially, depending on.
I mean,
that
the
would
towing
be-
company didn't look to find Miss Norman and give her a notice that she was in violation, or leave, say, a ticket, so to speak, on her car saying she was in violation, correct?
There was no ticket, and I understand that the tow happened at approximately 2 or 3 o'clock in the morning. So there was no phone call or no other personal notice provided.
Okay, the
Yeah.
only notice is in the rules
That's correct.
on the grass.
That being said, the rules make clear that there is no permission to park on the grass. The rules, I think, are very clear that vehicles parked on or across the grass are subject to towing at the owner's expense. That's the citation from the rules. The notice regarding towing from in the association's rules, that is a separate, that's the procedure by which the association, the appellee, would be able to tow from the association property, and that would have to have been pled as a violation of the association's rules, which it was not. In the trial court, the judge found that as far as the issue of permission, the rules are very clear that Miss Norman did not have permission to park on the ground, to be parked on.
So let
as
me
she-
get this straight. This is, I think you hit on a very important point because regardless of how we read the notice provision, the policy, and the statute, one other grounds in which the trial court made its decision was that the theory was not pled. But your opposing counsel has raised the point that it need not have been pled because this was essentially a defense. And, a plaintiff's allowed to address the defense at the time of summary judgment. They don't have to be prescient and understand all the defenses that could be raised. So what exactly was the cause of action based on, and how do you argue that forecloses them addressing the defense, if we perceive it as a defense, that was raised by the association at summary judgment?
The cause of action was presented as a violation of 715.07. It very clearly states as to Ashburn count 1, 715, a violation of 715.07. Pardon me. I believe it was the appellee's response to the plaintiff's motion for summary disposition filed in this case. We attached a copy of the parking rules to establish that she did not have permission to park on the grass.
So she says in her complaint, you violated 715.07 because I had permission to park in this parking lot, right?
They actually state it's based on the false premise that she was not parked on the grass.
So in the complaint,
Mhm.
the grass issue is raised.
Yes.
And so your theory in the trial court's theory was that so what was it that was not pled then? That was
That the appellant is arguing a violation of the association's rules. They've always pled it as a violation of 715.07. They've attempted to pivot and also argue a violation of the association's rules. That is a separate cause of action that should have been pled.
But isn't it a violation of 715.07 as they pled it? In other words, they said I had permission to park where I was parked. That's a violation of 1707. I mean, 1507.
And I believe in the trial court's order, Judge Tompkins kind of explains it and parses it out that the rules state she did not have permission to park on the grass. The question of the notice prior to tow, that is a separate issue, would be a question of a violation of the association's policy and procedures as far as towing. And that would have been a separate issue that would have needed to be pled.
Oh, the notice issue was was not pled.
Correct.
So let me get this straight. So your position, and you're reiterating Judge Tompkins' rationale. So you're conceding that what was pled was that she had permission to be parked where she was parked on the grass, or that it wasn't on the grass. But that they never argued in the complaint that, in the alternative, that, well, if I was on the grass, you couldn't tow me because you towed me before notice was given.
That's correct.
But this is small claims, and we know that pleadings are not as precise and as elaborate as they are under the regular civil rules. So how does that impact this? This is just supposed to be some general notice of a dispute. I don't know that the particularities of all aspects of it are expected in a small claims pleading.
And I do understand that, Your Honor. However, if you read through the statement of claim, they make it very clear that they are alleging a violation of 71507. There's no mention of a violation of the rules of Ashburn Square, of their parking policies, or of any of the deck.
I know, but I mean, the opposing counsel is going to get up there and argue this. I know because I read his brief. He's conceding that in all instances, it's a violation of 715.07. I mean, I can rephrase his argument, is that this is a straw man argument. That this is a straw man argument that no, you violated the policies. He's going to argue, as he did in his brief, no, it's still a 715.07 violation. The part about the policy is that you didn't provide me notice, either, which is a factor under 1715.07 and under the policy. It's still a statutory cause of action, he said.
And my response briefly to that would be, regardless of whether the policy was followed on that, she still didn't have permission to be parked under the grass. That would
Let
be
me
an
ask you this
issue.
though, is the notice issue subsumed within the permission analysis? In other words, you could look at it two different ways. So in other words, as I stated in response to his presentation before you had time to argue, there's two separate analyses under the statute. Permission is permission is permission, but could it also be argued that, well, really, permission, you don't have permission, your permission is not really revoked until notice is given.
In this case, I would argue that the permission is clearly, it's clear from the from the receipt of the parking policy that there is no permission. I think Your Honor kind of does hit the nail on the head, that the permission and notice issues do become very intertwined. And when we kind of go to counsel's analysis under 71507, specifically section 2A5, where it's argued that Norman was entitled to personal notice because she is not a, quote, unauthorized vehicle. That analysis is simply incorrect. If we really parse out the language of that paragraph, we can realize that there's really three separate kind of clauses within that paragraph. It's kind of a long paragraph. It's the third clause sets up the framework for what the towing signs have to say. Like, it have to include like the size of the print.
If you're looking at it, could you tell me where you are? Is that before towing or moving? Is that?
I'm sorry?
But could you, if you're looking at it, could you direct my attention to that where that clause begins? The third clause,
so
before towing or removing.
Yeah, so it's from 7/15/07.
I'm in the correct statute, I think.
Okay,
Five
so-
dot, before
Alright,
towing or
so-
removing any vehicle.
Okay, so it's the second clause, it's except for instances when notice is personally given. It's that clause. And it reads, except for instances when notice is personally given to the owner or other legally authorized person in control of the vehicle or vessel, that the area in which that vehicle or vessel is parked is reserved or otherwise unavailable for unauthorized vehicles or vessels, and that the vehicle or vessel is subject to being removed at the owner's or operator's expense. The appellants argued that towing only applies to towing signs. The towing signs are specific to unauthorized vehicles, and that his client was entitled to personal notice because her vehicle was not an unauthorized vehicle. If we read that full clause, we realize that's not correct. That clause, which the appellant is hanging their hat on, that she is entitled to personal notice, also applies to unauthorized vehicles, and that therefore their reading and understanding of what constitutes a quote unquote unauthorized vehicle is incorrect.
Okay,
That it-
so let me, so I follow you, and if I could see that, okay, yeah, so that clause includes not only unauthorized vehicles, but essentially vehicles parked where the parking is otherwise unavailable. Okay, but that still says personally given. So if you don't personally give notice to someone who's either unauthorized or who's parked, parked in where that's parking is unavailable, then what? Then what must have been done? Must
Then there's-
post notice meeting the following requirements. Did that happen?
those are the towing signs, yes.
No, but the towing signs don't talk about grass.
The towing signs do provide the notice that the quote unquote unauthorized vehicles are subject to towing, but it's what I'm pointing out here is that
Your
council's
argument, let me ask you, let me pose a devil's advocate here. Your argument would make more sense if you're conceding personal notice wasn't given, that, let's hear, the area is in which the vehicle is parked is unavailable, right? You're conceding that. So, and you're saying, and I'm conceding your argument that clause includes not only unauthorized vehicles, but vehicles parked, authorized vehicles parked where in an area that's otherwise unavailable. But you're conceding that personal notice was given to that. So then your client must have complied with that, everything that follows this phrase, must post notice meeting the following requirements. And you're saying they did so by virtue of a sign that only mentions unauthorized vehicles, that doesn't mention anything about an area in which the parking is unavailable to authorized vehicles.
And it's our position that the definition of unauthorized vehicles is not such that that appellant is arguing. It's our position that unauthorized does not simply means parked without permission, which once Miss Norman's vehicle entered onto the grass, she exceeded her permission as a resident of the association, that it had her vehicle remain fully on the parking pad within the parking space. She would have been parked with permission, even though she is a resident, but once her vehicle came off of that parking spot, then her parking exceeded the permission and became quote unauthorized.
So you're arguing, and then you're saying I misconstrued your argument, I think, that she was unauthorized because the area was unavailable. So in other words, every single car is the area, which is the grass, is unavailable. Are there any vehicles that are authorized to park on the grass?
No, none that I'm aware. I've been made aware of.
In other words, you're saying that all vehicles are unauthorized for that area.
And well, the statute doesn't speak about authorized or unauthorized. It speaks about being parked on the property with or without permission. Correct. So theoretically, a vehicle that is authorized for the community to park, generally in the community, could still be parked in a way that is without permission under the statute.
Correct.
That would be Ms. Burley's interpretation.
That would be correct.
Really, we have helped you use up your time. So,
That is correct.
thank you. Okay,
Thank
Mr.
you.
Mora?
Thank you for your time.
Yes, Your Honor, just to touch on that and to link to that very last issue, the statute uses the word authorized or unauthorized about 7 times in the context of authorized vehicle owners. So the unauthorized is always used in the context of who's a vehicle not subject to this community's permission. So it simply doesn't apply. Authorized is used authorized vehicle owners, and unauthorized is used in the context of the signs. To the issue regarding the not having pled this issue, we cited in our briefs cases for the proposition that under the small claims rules, concise pleading rules, we did not have to. We really look hard to a case where a lawyer representing a small claims plaintiff makes a difference. There isn't such case. So nothing changes. Ms. Norman could have filed the form for that matter, which says what happened, when, and how. So there wasn't nothing that required us that. In addition to that, we couldn't have possibly filed a cause of action under the parking policy because specifically says that you don't have relief under that. And if we had filed that, they would have moved to dismiss the case because we couldn't have a cause of action under that. So it was impossible. Ashburn won on summary judgment based on the policy. Our argument is simply the policy says something else. The very policy you're relying says something else that prevents you from obtaining summary judgment. We also make an argument in our brief regarding public policy and the interpretation of these conduct documents. And most of the cases either stay or go for the proposition that these documents have to be understood in the context of providing harmony and preventing chaos in these communities. Ms. Norman testified that she actually knew that this is a community with a history of predatory towing. She testified that at her deposition. So because of that, she was careful not to hit the other car, and she tried not to park on the grass. So interpreting this in the context of trying to create harmony and public policy, the type of arguments, I think a jury should have decided whether this was a violation or not.
So that sounds a lot like jury nullification, but I want to move to something different. I want to ask you a question. So going to what I was talking about of the statute. So the notice in the notice in the statute is not chronological. The requirement that there be a notice prior to the remaining, which is a condition precedent to towing, for lack of a better way to describe it, is not in the statute. So the statute says you don't have permission, you had to receive notice. And it says, unless you have personally given, and opposing counsel is saying that they're not two separate things, which is to say that either you're unauthorized or you're authorized in a reserved or unavailable area. It says area reserved or otherwise unavailable for unauthorized vehicles. So no vehicle is authorized to park in the grass, so the vehicle is unauthorized. And then tell me what the sign was supposed to say besides what the statute says here, which is unauthorized vehicles will be towed. Why wasn't a vehicle driven by your client on the grass, an unauthorized vehicle under whatever 2A5, you know the statute we're looking at, yeah.
Because reading the statute in a holistic way, one cannot possibly understood that unauthorized vehicles means vehicles that may inadvertently overstep in grass.
Well,
So,
what could someone understand that if they had read the policies for the housing complex in which they live?
correct, and that's why our case our case foundation from the pleading analysis, it's permission. And when we look at permission, what gives you permission? Your decal, your lease, and the rules that govern how this community should be, how you should park at this community. And when we look at
Would your client, if she had read the policy, have drawn the conclusion that her vehicle was one that was authorized to park in the area covered by grass?
Correct, but that's a
But
question.
what's the answer to that question? Would she understand that if she'd read, would she understand that that her vehicle was one that was authorized? And I'm reading the statute to park in the area covered by grass?
If she had parked four wheels on grass because she couldn't find a space and she was
I'm talking about notice though. I'm not talking about the factual issue that you think that half a car on grass is not on grass. I'm talking about notice. You're saying you said something earlier. You said, well, there's no way someone would know that she was not that she didn't have permission to park there just because she was on the grass. I'm challenging that. I'm saying how could she think that she was, to use the statutory language, not an unauthorized vehicle to park in that quote unquote area?
in this case for several reasons. She had a vehicle, she was in an assigned parking residential space, and she did not know she had parked on grass. She testified that at her deposition. And we cannot skip the personal notice requirement and the permission part. That's why our argument is it has to be read in whole. And when we link this to permission is given by the policy and the lease and the authorization to be there. So, and the policy Your Honors mentioned, it says following notice. The following necessarily logically means after. So the generic documents given by a resident when they move in cannot possibly.
But the statute doesn't require that. The statute doesn't require after notice. It doesn't require notice after violation.
But it also requires that you only tow vehicles without permission.
Okay,
That's what-
your time is up, Mr. Morris. So I think
Thank
you and Judge Atkinson should stop. Okay, thank you both very much. In order to leave our virtual courtroom, you should click the button in the corner of your Zoom screen that says leave, aptly named.
Thank you, Your Honors, for your time.
Thank you. Thank you both. Okay, Judge Morris is going to leave our session. He's waving goodbye. And Judge Kazam is now here. And put my glasses on. Well, if I understand this calendar correctly, we'll take up the next case, which is Patterson and